Understanding non-disclosure agreements, NDAs. Everything you need to know. What is a non-disclosure agreement, NDA? A non-disclosure agreement, NDA, is a legally binding contract that fosters a confidential relationship between two or more parties. It allows one party, typically the disclosing party, to share sensitive information with another party, the receiving party, under the assurance that the information will not be disclosed to outside parties. This included information can be vital to business strategies, proprietary technologies, or sensitive personal data. An NDA is also often referred to as a confidentiality agreement. Key takeaways. NDAs protect sensitive information shared between parties. Commonly used during negotiations, joint ventures, and employment relationships. They can be mutual or unilateral in nature. Breach of an NDA can lead to legal repercussions, including financial penalties. Purpose of non-disclosure agreements. NDAs serve crucial roles in various scenarios, especially in business dealings, where sensitive information needs protection. 1. Business negotiations. NDAs allow companies to discuss potential collaborations or joint ventures without risking exposure of proprietary information to competitors. 2. Employment. Organizations often require new hires or employees in key positions to sign NDAs to safeguard company secrets, strategies, or operational processes. 3. Investor discussions. Companies seeking investments may use NDAs to prevent sharing of sensitive business information with potential investors, creating a safe environment to discuss future projects. 2 primary types of NDAs. Mutual non-disclosure agreement. In mutual NDAs, both parties agree to protect each other's confidential information. This is typical when two businesses may share sensitive information during negotiations. For example, both companies may disclose intellectual property or business strategies, necessitating mutual protection. Non-mutual, unilateral, non-disclosure agreement. A unilateral NDA is one-sided, primarily used when only one party discloses sensitive information to another. This is often the case for employers and employees. The employee agrees not to disclose any confidential information regarding the company's operations. Disclosure agreements. While not strictly an NDA, a disclosure agreement is an opposite concept, where one party grants permission to share certain private information, often required in healthcare settings for insurance purposes. Key elements of an NDA. NDAs can be tailored to suit an array of situations, but they generally encompass 6 critical elements. 1. Participants, clearly defines the parties involved. This can include individuals, companies, or any representatives depending on the specific context. 2. Definition of confidential information, specifies what information is considered confidential. Properly defining this can be challenging but is crucial to the agreement. 3. Exclusions of confidentiality, states what information is not considered confidential. This typically includes publicly available data or information already known to the receiving party. 4. Appropriate uses of information, outlines how the receiving party may utilize the confidential information. Usage restrictions can prevent exploitation for personal gain. 5. Time period, specifies how long the NDA remains in effect. This could range from a few years to indefinite timeframes depending on the nature of the information. 6. Miscellaneous provisions, addresses other relevant details, including applicable laws, dispute resolution procedures, and specific terms for penalties in case of a breach. Information typically protected by NDAs. NDAs serve to safeguard various types of sensitive information, including customer data, personal and contact details about customers or clients, purchasing behaviors, and preferences. Financial information, non-public financial metrics, forecasts, and accounting practices crucial for business performance. Intellectual property, covering patents, copyrights, trade secrets, and proprietary technologies that give a competitive edge. Marketing strategies, confidential marketing campaigns, target audiences, and pricing policies that can significantly affect market positioning. Operational information, internal processes, supplier details, and payroll data that should not be disclosed. Limitations of NDAs. While NDAs are powerful tools for protecting sensitive information, they do come with limitations. Information that is public knowledge cannot be protected. If the recipient already knows the information before signing, it cannot be covered under the NDA. Information independently developed or acquired through legitimate means is also outside the NDA's provisions. Advantages and disadvantages of NDAs. Pros. Protection of sensitive information. NDAs prevent unauthorized disclosure of crucial business data. Clarity. They elaborate on what is confidential, reducing misunderstandings and liability. Cost efficiency. Drafting an NDA can be relatively inexpensive, often merely requiring legal consultations. Trust building. They outline consequences for breaches, helping foster trust between parties. Cons. Mistrust basis. They can create a foundation of distrust, potentially straining relationships. Attractiveness to talent. Employees may hesitate to join a firm requiring NDAs, fearing profiling limitations. Legal complications. Breaching an NDA can lead to legal disputes, which are often costly and damaging for relationships. Real-life example, Apple Inc. Apple Incorporated is notorious for its strict confidentiality measures, often requiring its partners and employees to sign NDAs to protect its competitive advantages. During discussions about a potential car project with Hyundai, the necessity of NDAs was highlighted as Apple insisted on keeping details under wraps to safeguard its innovations and proprietary strategies. Consequences of breaking a non-disclosure agreement. Violating an NDA does not typically entail criminal actions, however, it can lead to civil penalties like financial damages, termination of employment, or even more serious repercussions if trade secrets are involved. The consequences are generally outlined in the NDA itself. Duration and costs of an NDA. The lifespan of an NDA varies considerably, but they usually last from 1 to 10 years. Some can even be indefinite, provided they comply with state enforceability rules. Costs for NDAs range from $175 to $1,500, dependent on complexity and industry requirements. Conclusion. Non-disclosure agreements are essential tools utilized across various sectors to maintain confidentiality. Organizations can protect critical information while fostering relationships, allowing for strategic discussions without the risk of their sensitive data falling into the wrong hands. When drafted diligently, NDAs specify terms clearly, ensuring all parties understand their obligations and protections. As the business landscape evolves, understanding and leveraging NDAs will remain essential for protecting corporate and personal information.